Good night, Belizeans at home and abroad. This is the Belizeans Affairs Show number 418. 418. My name is Leonard Brackett. I'll be your chairman for tonight's program. And being Friday, we will try to fill in some constitutional uh, matters as well as case laws and other legal or um, judicious matters. Um, I would like to ask that you allow me to proceed with the program the way we normally do, which is to first of all say a short prayer and then do a little scripture reading, and then we get into the program proper. As of right now, there's no one else, none of the other colleagues are in the background or available. And in the interest of timeliness, I'll just proceed with uh, launching the program. I guess if they're able to show up, I'll just bring them on as they become available. But for right now, I'll just bow my head and let the program roll. Divine loving Father, we thank you again once more for having given us the privilege of life, first and foremost. And secondly, for giving us the opportunity to still be alive among our family members, friends, and loved ones today. Pray that thou must bless our family members, each and every one of them, as if they were each mentioned by name and number. That thou would bless our friends, that thou would bless all our other significant ones as well, and that thou would have mercy upon our country of Belize, its people and leadership, that thou must guide them, protect them, and look after them. We pray that thou must bless this country of the United States as well. Thou must bless the people and the country and its leaders. We also pray that thou must bless the rest of humanity, loving Father, especially those people who are in war zones, who are suffering sometimes for no justifiable reason. We pray that thou must be merciful upon them as well. And for those people who are in tornado areas and in earthquake and volcano areas and uh, other man-made disasters as well as natural disasters, we pray that thou must grant them some relief. Please continue to be merciful unto us, and whatever we have to say tonight on our program, may it accrue to some positive public benefit to our Belizean people at home and abroad. For we ask these mercies in Jesus' name. Amen. I'll just proceed to read a small portion of the scriptures here. Let's see which, where am I going to read from now? Okay, I'll read from the book of Luke, St. Luke, chapter 6, and I'll read verses, starting at verse 20. It goes on to say, or reads as follows: And he lifted up his eyes on his disciples and said, Blessed be the poor, for yours is the kingdom of God. Blessed are ye that hunger now, for ye shall be filled. Blessed are ye that weep now, for you shall laugh. And at verse 22 it goes on to say, Blessed are ye when men shall hate you, and when they shall separate you from their company, and shall reproach you and cast out your name as evil for the Son of Man's sake. And that will be the ending of our reading for tonight. Thank you very much for being patient with us as we indulge in the different parts of our program format. And now I can go into the program proper. Um, just spare me a second. Let me just launch this other portion of our live broadcast. Give me a couple of. Let's see. Yeah, okay. So, okay. Yeah, 2%, that's good enough. So sustain that. And then I just need to grab this other part here. Okay. Belizean affairs, and then we go to okay. Um, for tonight, we're going to talk about as our main focus. We're going to talk about the government violating Section 90 of the Constitution of Belize and other sections. As we have said before, on many occasions, and particularly on the Friday programs, which we deal with the Constitution, I'm sorry. As often as possible, we try to read or quote or cite Section 2, subsection 1 of the Constitution of Belize, which goes as follows. This Constitution is the supreme law of Belize, and if any other law, and those of you who may remember why is it that I always emphasize the other law, I'll come back to that afterwards. I'll just finish the citation and reading. And if any other law is inconsistent with the Constitution of Belize, then that other law, to the extent of its inconsistencies, is void. That is to say, the other law that we're referring to are what you call substantive laws that the legislature of the country of Belize is empowered to make. That is, that they have the authority to make laws and to modify some portions of the Constitution itself, but not all parts of the Constitution. They don't have that as a vested power in them without them coming to the populace and gain a specific mandate through a referendum to have the plebiscite say yes or no as regards to some particular sections of the Constitution that they are not authorized to tamper with or to alter. A lot of our Belizean people, and even some of our lawyers, and not only just regular lawyers, but some senior counselors, some of them who have become attorney general in our country, are of this opinion that because the legislature is empowered to make laws and alter laws, that they can make just about any law that comes out of the side of their ears, or they can eviscerate just about any law that is in the Constitution, or replace any law in the Constitution on their own, because they are authorized to make laws. But the authority vested in them to make laws specifically dictate that anything that they make as a proposed law if it's inconsistent with the Constitution, those proposed laws are null and void to the extent that they violate the Constitution, that they are violative of the Constitution. Why? Because as we read, and I pointed out earlier, the Constitution is the supreme law of Belize. And if any other law is inconsistent with the Constitution, which is that if any other legislative bodies make a law or any department of government make a ruling or department guidelines or regulations or whatever that is inconsistent with the Constitution, then those other law or procedures, protocols or practices or whatever are to be deemed as null and void. Why? They contravene the Constitution. They contravene the highest law of the land. They are violative of the highest law of the land. And we can only have one law at a time. I mean, one constitution at a time. And whatever law they make must come under the aegises or within the bounds of the four sides of the Constitution. So we have a situation where we had 3 cases that went to the court, the Supreme Court, and what we now call the High Court of Belize. We had 3 different cases that were taken to that high body for resolution. And those cases that were taken to the court for resolution under judicial review, Section 20 of the Constitution of Belize, the court took jurisdiction of those cases, accepted those cases for them to review and render a decision. But in the 3 cases and the 3 instances of which we are going to be talking about tonight, they fail to do what is required of them as judges in those cases because they violated their judicial code of ethics in regards to how they dispose of those cases. In one instance, they did not actually rule as per the Constitution, even though they had granted permission to the government, who was being sued by some civilians, for the government to comply with the constitutional requirements and prescripts. The judge went ahead and took the word of the government officials to say that they had committed, first of all, they asked the government, they acknowledged to the government in the case, they acknowledged to the judge that held jurisdiction of that particular case that yes, they acknowledged that they had been in breach of the Constitution. And they requested of the judge that the judge would have the plaintiff accept the government promise to go and make amends or to go and redress their violation and to correct their violation. The judge had jurisdiction of that case, and yet, after she allowed the government to get off without her having to rule on the case, the government went and didn't do what they were supposed to do based on what they had agreed to do. So the plaintiffs went back to court and asked the judge to pressure the government to do what's right or to make a ruling and to stipulate what the government must do in order to remedy their constitutional violations. Only to have the judge turn around and tell the plaintiffs she can't help them with that. Why? Because they allow themselves to be conned by her, the judge, and the government lawyers into accepting what she then classified as a tumbling agreement which is to say, if because you went into that agreement with the government that you were suing, whatever the government did and promised to do and didn't do is immaterial because you dared to enter into that agreement. Therefore, you, according to her judge, and I'll call her name, Judge Naby of the Supreme Court, because I don't want no other judge to feel like, well, I'm talking about them or trying to refer to them as being the one. I'm just going to call the name of the correct person that, messed up on that particular case and did not do justice as is required of her under Section 20 of the Constitution and Section 95, 94, 95, and 96 of the Constitution of Belize, which empowers judges to have unlimited jurisdictions when it comes to dealing with matters that are brought before their presence for a resolution, especially as regards to constitutional matters, as well as criminal matters. So they are empowered with unlimited jurisdiction to review just about any case that is brought to them. And they fail to deal with those matters. And in the particular case that I'm referring to right now under Judge Naby, she's going to tell the plaintiff then that she can be of no help to them because their case suffered a flaw by her authorizing them to go ahead and enter into an agreement with the government that the government refused to fulfill or to abide by. So she can't force the government to abide by something that she had jurisdiction to rule on, did not rule on, but encouraged the plaintiff to accept the government premise that the government was not being sued for money. They were just being sued to do what was right according to the Constitution. And since the government promised to go and do what they were supposed to do, and she entertained that as a way for the solution to the case, and the plaintiff agreed to let the government have the time to remedy the stuff. When the government did not remedy the stuff, and the plaintiff went back to the court to have the matter be ruled upon with a finality, the judge decided to exculpate the government and refused to take the complaint of the plaintiff with any level of seriousness. Why? Because she didn't want to have no problems with the government that hired her and pays her salary. She decided, as a judge, all judges have to make a ruling on a case when a case is brought before them. She decided to throw these people in a case, basically, from a state in a raw, derogatory manner. Because that's what she did, for all intents and purposes, was to throw the people in a case. Put them in a bind because she knew that they were not moneyed people. And the way how she tried to dispose of the case without ruling on the constitutional merits of the case, but try to push the case off on a side deal, on a technicality that she herself encouraged these people to get into. And then she took 40 pages to explain what she was explaining in terms of how she encouraged these people who were novice and who didn't understood much of these things anyhow. Why is it then that she found it necessary to exculpate the government, to throw these people their case, and to have nothing else to do with it, and to other than to say, well, the case has a flaw, and she can't help them resolve that flaw? When she had jurisdiction of the case, she had to rule on the merits of the case and the constitutional validity of that case. She does it. So the people, they complain. She said if they want, somebody else could bring the case, but they, the individual that had entered into that agreement with the government, cannot bring the case or cannot carry the case in any way forward, because she, what you call, put an estoppel on the case. That is that she disposed of the case without ruling or addressing the merits of the case, and therefore they were stopped from having a legal ability to be able to carry the case forward and do anything about it, because after all, they had no money to go above her head to appeal her disposition of the case. I wouldn't even call it a ruling, okay? Because a ruling would have been a finality of the case. She did not brought the case to a finality. She does the legal requirement and the constitutional requirement to rule on the constitutional merits of that case. So another group of individuals decided to take up the matter and file to have the matter being heard on the constitutional merits. And they refused to enter into any agreement with the government, as the previous individuals had done. I see someone in the background. I see one person in the background. It looks to me like it's my cousin, and he can bring himself in. Good evening, Greg.
Good evening, Mr. Chairman.
Yield to you for your self-identification, sir.
Good night to the people at home and abroad. My name is Mr. Brackett also, Gregory the First. Thanking you to tune in to this 418th episode of Belizean Affairs. I go back to you, Mr. Chairman.
Thank you very much, sir. I was speaking for tonight. I was mentioning to the general public, those who are listening to our program now and those who will be hearing it afterwards, that the essence of tonight's program would have been about the Section 90 of the Constitution of Belize being violated by the government, and the various approaches that citizens took to try and get the governments to comply with the constitutional requirements. And I was at the point where I was stipulating that there were 3 different cases. The one that I finished talking about was the first case with Mr. Parker Smith and I think it was 6 or 7 other individuals. And after Judge Neby had ruled on that, Mr. Wade, our colleague and panelist on our show, along with another group of individuals, had filed the case without having to enter into any agreement with the government like the previous case was sidelined for. And therefore, the case that they had submitted should have been given a timely review in order for the whatever conclusion would have come out of that particular case, for them to be able to use that to force the government to abide by the constitutional requirements that the government had already acknowledged they were in breach of. And therefore, in regards to that case was heard by by Judge Hondura, Justice Hondura, because Supreme Court we're talking about. We're not talking just about a regular judge, or we're talking about Supreme Court justices. So I need to
High Court, Mr. Brackett.
Yes, sir. I'm sorry.
High Court.
Yeah.
High Court.
The High Court, which I also referred to earlier and made mention that it used to be called the Supreme Court, and now it's the Supreme Court / High Court of Belize. That is to say, the new name is the more preferable name that they would like for everybody to get used to and stop referring to the entity as the Supreme Court, but rather as the High Court. There's a canard there too that I think I need to bring forward, and that is that there was no justification for them to classify the Supreme Court as the High Court and then disband the original title of Supreme Court. This is a technical issue, right? Because in Belize, we have what you call a higher court than what they were trying to call as the High Court. Because the appellate court, the local appellate court in Belize, is higher than the Supreme Court. I'm not too sure how many people are aware of that. That is that the matters that are dealt with by the new High Court, previously Supreme Court, when they are appealed by either the government or any private person or entity, they are appealing to a higher court. And that higher court then, the second level court in our total area of jurisdiction in regards to our legal standing, constitutional matters especially, is the appellate court. And then that appellate court, if for whatever reason the government or any citizen or anybody that is aggrieved about the decision that is made at the Supreme Court or High Court, can appeal to that appellate court, which is higher than the High Court, and therefore that's why I said it's a canard, because then that appellate court, which is higher than the High Court, is still not the highest court in our land. Therefore, the High Court title should be reserved for what we call the CCJ, the Caribbean Court of Justice. That's our highest court, and that should be classified as the High Court. If we're not going to be, doing what you call misnomers or misnaming or attributing titles to a subordinate court that is not the High Court. Again, that is not part of my intention to get into that tonight, but just because it came up as a bypassing point. And I would have liked to clarify or throw some additional thoughts out there about that, because a lot of people do not realize that when we do misnomers or we use the wrong title or attribution, we can mislead or have people be, get misinformation. Not everybody is at the same level in terms of the awareness and knowledge of these process, procedures, protocols, and these legal issues. So I don't know why they did decide to change that from the Supreme Court, which was an adequate title, which we have all been used to the High Court, other than for the purpose that I can speculate that at some point in the future they will want to have the Supreme Court be the highest court in our land after we become the independent Republic of Belize. I mean, I can give it to them if that is a future, but currently, to stick their fingers into the present situation and stir it up for mischief-making purposes, it doesn't jive, or it shouldn't jive. Because our highest court is not the High Court of Belize. It is not the appellate court of Belize, but it actually is the replacement for the Privy Court, which used to be our highest court a while back, but is now deferred to as our High Court or highest court, being the CCJ, the Caribbean Court of Justice. And that's the way how it should be understood by most people who are, of course, as I'm saying, I'm going off on a part there because that point came up, and I just wanted to throw a little something in there for people to think about and get to understand. Nevertheless, I want to go back to my point of focus, because I would like to ask Mr. Brackett to weigh in at some point in terms of his contribution of some of his thoughts in regards to these matters. I'll go back to the issue that the matter was taken to the appellate court. That is that we're talking about three different matters. I'm hoping I'm not going to confuse people. The first matter, as I said, was disposed of, apparently according to Judge Nabi and her authority. She sidelined the case. She did not address the fundamental basis or substantive issues of the constitutionality of that particular case, which why then the second case came about, and that was dealt with by Justice Hondura, who, while sitting on the bench at one point with another case with Mr. Ram Logan and Mr. Jeremy Henriquez case, which relates to the same some of the same issues about the government violating the Constitution and not abiding by the Constitution and doing the 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 I'm drawing blanks. Not following through by do the revisioning and the reapportionment that is required to be done at least every 10 years as a minimum, you know, and it hasn't been done, and it keep on being pushed aside, and they keep promising that they're going to do it, and they don't get it done. And as of right now, we are about to have another election with the same bogus, um, unconstitutional violation. So I just want to stop for a little while and then let Greg weigh in a little bit from his perspective. Mr. Brackett, I yield to you, sir, for whatever contribution I might have available to us.
Thank you, Mr. Chairman. The three
You're welcome.
cases we are talking about has to do with redistricting. I want to say that when these cases were taken to court, these cases were taken to court based on the Belize Constitution. And the judges who were presiding over these cases misinterpret the law. That is my belief. Because they wanted to take a constitutional case that you cannot bypass. And they wanted to term it as justiciability, meaning they want to claim that a judge cannot answer political questions when the case was not about political questions, but it was pushed in that direction by the government's attorney, who
Mm-hmm.
was the first one to came up with this idea that they file an injunction to stop the election. Nobody was trying to stop the election. They wanted their case to be heard. It did not matter if it was before the election or after the election. And that is why the case was not being heard. But as we look at the ruling at the CCJ and we listen to what the Prime Minister says about the ruling is moot, I personally believe that the Prime Minister was speaking out of context
Exactly.
because a ruling cannot be moot when it is based on the Constitution of Belize, when you have individual rights being violated. The High Court must answer to these questions. And so I'm looking forward to see what will be done in regard to the ruling from the CCJ because I want to see what the government intends to do. I go back to you, Mr. Brackett.
Uh, Thank you very much, sir. Okay. Just want to pull up something here quickly. You have another couple of comments to make, maybe for about 10, 15 seconds, just to give me a chance to pull this stuff up. Great.
I want to say this to the Belizean people at home and abroad. We must pay keen attention to what is happening in Belize and the way this country is being run. An incident happened today, the budget hearing, and I look on it as a gross violation of our constitution. And I want to go to the tape since tonight is Constitution Night, so you, the people at home and abroad, can hear this.
and I ask that the question be put.
Honourable members, the question is that a bill for an act to appropriate certain sums of money for the use of the public service of Belize for the financial year ending March 31,
Madam President,
2027 be read a second time. All those in favour kindly say aye.
Madam President,
Those against kindly say no.
Madam
The
President,
ayes have it. Senator Pitts, I was concluding the budget debate. Do you have a point of order?
Madam President, what I will say is this, and I invite your indulgence. Before we began the debate, Madam President came over this side to share how the debates would go, to indicate who speaks, who doesn't speak. At that time, I can say, Madam President knew that I intended to speak. And my record in this Senate has always been to provide interventions. Now, it is rather unfortunate that my interruption to the House of Commons invited your good self to permit the closure of debates, knowing that I had every intention to contribute to the debate, but for being in the House of Commons. And I must say, Madam President, I am truly, truly disappointed in the discharge and conduct and how it resulted in your closing this debate, knowing by my record, by my indication today, that there is never a time I come here to not contribute to nation building. And so, the closure of this debate by the leader of government business also betrays the population of the people to which this side of the bench represents. And that strikes more grave to the heart of what we call a democratic system, because you don't do things high-handed like that.
Senator.
So there you go, people at home and abroad. Senator Pitt was barred from taking part in the Senate debate, which to me is an unconstitutional move when it comes to the democracy of this country. Mr. Brackett, I go to you.
Thank you very much, sir. I would like to speak to that matter, and it's kind of segueing away from what I was hoping to finish saying, no, but since it's already brought up and within the context of what is being discussed, I would like to speak to that matter. First and foremost, the president of the Senate, that is how they call the individual who sits on the chair, as the chair of the Senate itself, I think, if I'm not mistaken, should not have allowed that to happen in the first place. Because that is why they have these procedures, protocols, and these rules and regulations of the Senate, and the rights and authority vested in each senator, and the rights for each senator to have equal opportunity to participate as any other. And it appears to me to have been a deliberate action on the part of the head of the Senate there at that point, because she heard Senator Pitts trying to interject when the leader of government business, the knucklehead, senior attorney, and bamboozler extraordinaire, attempted to have the chair close the meeting. The chair should have entertained an objection to that to that request. She should not have just pretended like she's not hearing what Senator Pitts was attempting to do, that is to call her attention to the fact that she had not spoken and needed to be given her rights under the rules and regulations. These jackals are always at every step of the way power playing the process and trying to use malignant attitude and conduct or behavior to play roughshod or run roughshod over our system of governance. It's intolerable. And I dare say that that is how and why sometimes some members of the House, inclusive, as well as members of the Senate, inclusive, during debate times, get cantankerous and sometimes even misbehave. Because the people who are supposed to control the process play favoritism, play power players, and deny people their rights. That is a constitutional right by that member of the Senate to speak. And she alluded to the fact that she had already told the head of you'll call the president of the Senate, that she intended to speak. So why the hell deny her chance? And when she's asking to be given her chance, they play like they can't hear her until after when they don't close off the Senate meeting. Then he turn around and ask her, well, what do you want to say? And because then at that, under protocols and procedures, the meeting is already closed. She already forced the process to make the meeting close before he entertained even any thought from a young lady from his spits. So that she herself could have been appraised of the fact that she's doing something or contravening the rules and regulations, the very rules that she's supposed to be upholding and guiding everybody else with. That's how they act as a bunch of jackals and scarflowers. They don't abide by even the rules. I have a lot more I would like to say about that. I think I'm going to have to defer that particular extra comments that I would like to say for another occasion, because seriously, I don't want to get off the beaten path.
Go ahead, sir.
And I just want, I wanted to read section 20 of the Constitution, to which you alluded earlier, so that people can hear what is it that we are talking about. When we make these references, or when we quote these or cite these sections of the Constitution, sometimes people don't know what is it that the section represents, or what is it that we're talking about. And as this Friday night thing, as we were trying to do as an endeavor, as we said, is about teachable moments. It's about educating the general public. We're not doing this for the benefit of the lawyers, which some of them should pay attention as well. Because it appears to me, based on what I said earlier, about some of them, even at the level of being attorney generals themselves, seem not to know or understand what the Constitution of Belize is, because they argue contrary to the written prescripts. But let me read this thing so other people could read and understand what we had cited, okay? The Constitution of Belize, Section 20, enforcement of protective provisions. That is to say, how you go about getting enforcement of these protective provisions that are not supposed to be violated, that the government cannot make any laws to violate. Under Section 20, subsection 1, it reads as follows. If any person shall allege, or if any person alleges that any of the provisions of Section 3 to 19 of the Constitution of Belize, inclusive, has been, or is being, or likely to be contravened in relation to him, or in the case of a person who is detained, if any other person alleges such a contravention in relation to the detained person, then, without prejudice to any other actions with respect to the same matter as aforementioned, which is lawfully available, that person or that other person making the allegation on behalf of the person that is detained may apply to the Supreme Court for redress. The Supreme Court shall, not may. The Constitution of Belize command the Supreme Court, based on the power that the very same Constitution is vesting in the Supreme Court, and the officers of the Supreme Court, which includes lawyers, by the way, because they are officers of the court, judges, jurists, and all other employees who work under the judiciary. The Supreme Court shall have original jurisdiction, as I previously stated. And not just original jurisdiction alone, but they shall have unlimited jurisdiction, okay? Which is another stage far beyond just having jurisdiction. You have unlimited jurisdiction. So as regards to what Justice Naby had stipulated in the first case, as I previously pointed out, she had to have known her judicial powers and authorities. She cannot act and pretend that she's not aware, or that she can just dismiss the powers and authorities vested in her and directed at her in how she should carry out the judicial responsibilities. As a justice, before she starts acting as a justice, she has to swear allegiance to the Constitution of Belize, which she should be appraised or learn or know something about before she's allowed to make rulings on matters relating to the people and country of Belize. I would never say that Judge Naby should not have known or may not have known. But because I know that they have to know those things, and as a matter of fact, the Constitution of Belize is so small compared to the experience that these people bring from all these other countries abroad that they work in before we hire them, it leads me to believe that it's skullduggery that they're actually dealing with or attempting to foster on our society. They're weighing in on the wishes of the executive and violating their own code of ethics and conduct. The temperament of a judge should be one that judge recognizes the supremacy of the Constitution, as I read and stipulated and cited earlier under Section 2 of the Constitution, subsection 1, which says that no other law that is inconsistent with the Constitution of Belize is supposed to be tolerated or accepted as being valid or viable, because they're not. They're null and void to the extent of their inconsistency. So no judge should come to Belize and rule on a Belizean constitutional matter while ignoring and pretending that the Constitution does not exist because she ignores it. They have to follow the law. Section 20 tells them that they must hear any and every case brought to them, especially as regards to the matters under Section 3 all the way through Section 19, including Section 20, for judicial review. And like I said, if you go to Section 94, it empowers them beyond that point to say that they have unlimited jurisdiction. So why Justice Naby will tell the plaintiff in a constitutional case that she cannot help them? Who the hell else are they supposed to go to for redress other than coming to the Supreme Court? Only for her to throw the people in the case out the door because they can't rule on their one case themselves. It is left to her to do what she's empowered to do and required to do, as stipulated here. They shall. The Constitution doesn't ask the judges if they want to do what's right or if they want to follow the Constitution. They shall. They're commanded. They're mandated to follow certain process, procedures, protocols, and precepts. And the Constitution is the supreme law. So if you have a Section 90 violation that the very government lawyers acknowledge that they're in violation of, and that they're asking the judge to use her discretion under the law and the authority and power vested in her to give them a chance to go and correct. And she goes ahead and encourage the people that are bringing the lawsuit to go along with that agenda. And the people accept, okay, well, since they weren't suing for no money or no other else thing other than just to have the government do what was right, they don't have a problem. Let them go ahead and do what's right, because that's all we're suing them for. And then the government go and don't do what they commit to do. And these people come back to the judge, who retained jurisdiction of the case because the case had not been finished. Okay? Then the slick judge is going to turn around and say, well, she can't be of no help. In other words, she retained jurisdiction of the case, but she can't help the plaintiff because she don't want to go up against the government. For all intents and purposes, that's what was being stipulated by action. Not in words, by action. And as a judge, the action of the judge speaks volumes about the standing of the law in the country. No judge can rule according to their own personal emotions while dispensing with the law and the Constitution itself. That's a violation of their professional ethics. I yield back for another minute, Greg, if you want to what's the little contribution, little thought or something.
You are right about that. And I want to say this because I listened to what the Prime Minister had to say, right? And I want to play what he said.
The CCJ ruling on the Jeremy Enriquez case in terms of the redistricting, is it a moot point because the government is already planning to proceed with that?
Well, I have not seen the report, but I think it's, at this point, you're right, it's moot because we are already working on the redistricting. And I'm still pushing. I should have a meeting with Minister Musa on Monday to get an update as to how is it going, so that we can ensure that we can keep our timeline, that we hope that can be in place by the end of this year.
I personally call this a political blunder. Because if the CCJ hadn't came down with a ruling, you would have never heard the government is doing redistricting. So I believe they came together and came up with this idea as quickly as possible to say that the redistricting was taking place. And I'm saying this to say the Prime Minister himself said the redistricting would cost so much money and it would take so long. So how come it will be finished by the end of the year, or hopefully be done by the end of the year? I want them to make that make sense to me, because the public is not being informed. There is no meeting to say what is going on. There is nothing being said on the radio station or the national TV. So I hope you, the public, be aware and listen and keep your eyes open to what is happening. I go to you, Mr. Chairman.
Thank you very much, sir. I'll be coming into the Mr. Enriquez issue in just another moment. I just want to read something else here from the Constitution that I cited and made reference to earlier for public consumption. And that is, I cited Section 94 of the Constitution, as well as 95. And I'd just like to read a little part of it for people to get a flair of what it's all about. 94, Section 94 of the Constitution of Belize is about establishment of Supreme Court and Court of Appeal, to which I had referred earlier. Okay, let me read the first part, 94, before I go to. It's very short. 94 is about probably 12 words at the most. There shall be for Belize a Supreme Court of Judicature and Court of Appeal, to which I had referred earlier, right? When I said the Supreme Court by title, as we had known it before, which is now being changed to the new title of High Court. The High Court of Belize actually is not the Supreme Court. That's what they're trying to have us buy into. And like I said, there are nefarious reasons why that was stipulated as such. But let me not go into the nefarious reasons, and there's too much material to cover, and I need to try and stay focused. Under Section 94, it reads subsection 1 as follows. The Supreme Court shall have unlimited original jurisdiction. Remember I made mention of that earlier? When I read Section 20, I said it has jurisdiction over all matters that relates to Section 3 all the way through Section 19. Those are the fundamental rights that neither the government nor the assembly can make law or propagate laws or have any legality or rights over the population to abrogate or violate any of the fundamental rights of the citizens of Belize. But yet we have these jackals, scofflaws that constantly, at every turn, you have them trying to commit these violations and breach. And then they go to the House and try to make laws that are onerous in the first place because they know those laws aren't supposed to be made. But because they make the law, those particular laws, they bamboozle the people and have the people believe that the authority that they are vested with to make law includes making a law that is illegal. You cannot make an illegal law be legal. If it's illegal, it's illegal. If it's legal, it's legal. And it cannot be legal or lawful or constitutional if it violates the Constitution. How much time they have to hear that? Because as far as we are concerned on this particular program, we have said that more than, we have what? 418 programs as of tonight. And on Fridays especially, including other days besides Fridays, we have had discussions on these matters as well. And so therefore, we can safely say at least over 500 times they have been made aware of these transgressions. And they keep perpetrating them. As if to say, well, what the heck? We don't care about no law. We don't care about no constitution. Whatever we want to do, we do. Because why? We are the government. They fail to understand that they are governing on behalf of the people. They are governing our country, our patrimony. In other words, they need to recognize the fact that they are hired employees. But they don't behave like that. Once they win the election and pay whoever they pay $50 each to get their vote, they feel like they own the country and the assets of the country, that they can then go ahead and do just about what they want and, disregard rules, regulations, laws, or constitution. The laws come out of their head. Whatever comes out of their head, becomes the law of the day or of the moment. That's how these jackals and scarflaw wants to run our country. And a lot of people are apparently, because they get a little $50 or they get a little piece of land from these people or they get some kind of little kickback from them, they feel like they have to aid and abet this kind of criminal conduct. I'll read a little further on. It goes on to say, okay, let me. Section 95, so Section 1 reads as follows. The Supreme Court shall, it's a command, have unlimited original jurisdiction. That is to say, they can rule on just about any case that is brought to them, to hear and determine any civil or criminal proceedings under any law, and such jurisdiction and powers as may be conferred on it by the Constitution or any other law, provided that the Supreme Court shall not have jurisdiction to hear and determine any application made by a person sentenced to death under any law after the expiration of 1 year from the passing of that sentence. Right there at that point, I want to say something else too, right? Does the Prime Minister have any power to commute anybody's sentence or even a death sentence? That power is reserved to the head of state and may be exercised by the Governor General. The Prime Minister doesn't have any such authority. Anything that has to do with the legal structure in reference to the Constitution itself and or in reference to the judiciary is outside of the limits or the purview of the Prime Minister. But yet he took on to himself, used his position as Prime Minister to demand that the Budna report come to his desk for him to peruse and decide what he wants to do with it afterwards. He's acting in that sense as a scarflan, a dictator, abusing the powers vested in him as the head of the administration. You know, at that point, he's abusing the conferred executive powers that does not authorize him to step in and violate the powers of the Supreme Court and or of the judiciary, because his position as a Prime Minister falls under the executive of the state. And it's a different function or power than that of the judiciary. It's also a different power than that of the executive, of the legislative. Because we have separations of powers doctrine and a separation of power democracy. I want to read a little bit more here, and then I'm going to come to you, Greg, for you to bless us with some comments or perspectives. The Justice of the Supreme Court shall be the Chief Justice and such numbers of other justices as may from time to time be prescribed by the National Assembly, provided that the office of a justice shall not be abolished while there is a substantive holder thereof. The Supreme Court shall be a superior court of record, and, save as otherwise provided by any law, shall have all the powers of such a court. The Supreme Court shall sit in such places as the Chief Justice may appoint. And that is the end of section 95, which is what I was alluding to earlier when I made mention about the powers and authority vested in the Supreme Court, now being called our High Court. But even at that level, we have the appellate court. And even beyond the appellate court, we have the final jurisdiction of appeal, which is our highest court. After that highest court makes its ruling, decides its judgment, and makes its ruling, then that ruling becomes a standard bottom line basis for the appellate court below it and the Supreme Court below it to render justice to the population and the people. Because those decisions by the highest level court then become what you have constantly been referring to as stare decisis law and or settled law. Once a judgment goes all through the three levels of our legal system and it is made a final ruling upon, that becomes the basis for any other such similar case. But these guys don't abide by that, because the Supreme Court has spoken in some regards and they still dismiss it. They don't go to the appellate court to get it appealed because they know they're going to lose at that level. In some other cases that they have actually gone to the appellate court, and like I said I think it was might have been Wednesday or Monday, that I made reference to the fact that the government had one of his minister's wife being put on the appellate court in order for that particular individual to help the government overturn the Supreme Court decision, so that the people that the government need to pay will not have money to go beyond that appellate court level to go and get the CCJ to vindicate their rights. That's what happened in the case of Mr. Jeremy Enriquez and Mr. Ram Logan, which I think is the next point that we would like to deal with specifically. You had played the tape about it before, Greg, but I would like to solicit your input on the piece that I just made reference to in terms of the power and authority of the Supreme Court and the unlimited jurisdiction issues. Could you help us with that?
When it comes to the High Court and cases are presented, they either be justiciable, meaning they can be heard, or they become justiciability, meaning they will not be heard. In the case with Mr. Enriquez and how it was presented by the government attorney, as I stated before, they wanted to make sure it falls under a political question, or the way they presented it is as though Mr. Enriquez was trying to stop the election. And I believe that is why the judge sided with them. But I want to say this.
Sir, before I leave that point, could I interject something right there?
Go ahead, sir.
Thank you, sir. What had happened is that when Mr. Enriquez's case was filed, they did the same thing that they did when the second case was filed by Mr. Wade and his group. That is that the high-powered lawyers that the government contracted, Mr. Courtney and Coy law firm, which had about almost a dozen different lawyers and other support personnel, and Mr. Smith, it was Godfrey Smith, right? Whose law firm also was much bigger than the Pitts law firm. So those two major law firms ganged up on the Pitts law firm, who was responding on behalf of Mr. Wade and his crew, and they impressed on the judge to have the judge look at the material that they were submitting in response to the claimant's case, and they turn around the claimant's case from what the claimants had claimed to something other than what should have been entertained by the judge, and the judge let them get away with that. That is to say, instead of answering the claimant's claim or responding to the claimant's claim, they responded to something that was not part of the case. And the judge allowed them to run with that and allow that to become the focus of the case, to the point where they totally ignored what was submitted as the original plaintiff case. They did not answer to. When I read their response, it had no context or reply to the original case that was filed. And the judge allowed them to play that game all the way through from beginning to the end of the time when the judge tried, because as of right now, I'm saying what that judge did was a contravention of laws and legality, and for that alone, he should have been disbarred from being able to operate anymore in the country of Belize. He should have been, as a matter of fact, there is still an outstanding issue in regards to how that particular judge is going to suffer consequences for his misbehavior in regards to the Ramlogan Enriquez case. But Mr. Enriquez, the lawyer, Mr. Courtney, tried to impress on the judge that Mr. Enriquez's lawyer was not even legitimately capable of operating in the Belize because he was not properly registered. All these kind of technicalities and underhanded craziness they were trying to use to kick out the case. They didn't want to answer the case. They refused to answer the case. And the judges then went along with that. Then Judge Hondura got off his bench while the case was going on, got off the bench, went into his side vestibule room, and called the first judge of the original case, Judge Naby, and inquired of Judge Naby how is it that she had disposed of the first part of the case, and if the second part of the case does not have an estoppel to it, that he could actually kick these people in the case out as well, because Judge Naby had already covered it. When in fact, Judge Naby's ruling, which again I'm not even, I got to call it a ruling because for all intents and purposes that's what was attempted, but it was not a real ruling per se, because the case was basically just pushed aside. It was never dealt with or addressed correctly. The substantive case, the constitutional matter, was never dealt with. So that's why I brought it up a second time. And the second time, Judge Naby, as part of the conversation that she had with Judge Hondura, asked Judge Hondura if Mr. Courtney wasn't in the court, that he should actually refer to Mr. Courtney to have Mr. Courtney figure out how they want to deal with this matter, or how they want to kick it out, or what they want to use as justification to guide for the final outcome of the case. They've been playing hanky-panky with the government from the very get-go. And bits and pieces came out in public that, I mean, when you do things in the dark and you do malicious things, sometimes karma have a way of getting you. And that's what happened to Judge Hondura. He was allowed to lie and to impeach himself, and the evidence came out and proved that he actually had lied and he impeached himself. Then he wants to turn around and victimize the plaintiff lawyer and play games. Initially, they had said that they wasn't going to try and charge no fee because the government was going to, it's government lawyers and it's public expenses and everything. So they weren't going to try and penalize the civilians them that brought the suit. But at the end of the day, they still turn around and try to play with the lawyer, with Mr. Ramlogan, the lawyer, to try and discourage him from supporting the civilians in their case. They turn around and try to collect money out of him and say that he had caused gratuitous expenditures to be incurred, and therefore they had a reason and a right to demand restitution from him. Anyhow, I yield back for a second, Greg. Make you clean that up, yeah?
What I want to do is go to the tape from Mr. Ramlogan to hear what he said when the ruling came from the CCJ.
Go right ahead, sir. Yeah, I yield.
The Court of Appeal struck out and dismissed all the appeals we filed. We filed an appeal against the refusal to grant the injunction. We filed an appeal against the wasted cost order, and we filed an appeal against the judgment he delivered in the bias application without giving anyone an opportunity to be heard. The Court of Appeal struck off all three on technical grounds raised by the attorneys representing the Attorney General and the Election and Boundaries Commission. It was in those circumstances we immediately had no choice but to appeal to the Caribbean Court of Justice. We applied for special leave, and to our great surprise and delight, the Caribbean Court of Justice said that they will treat the applications for special leave as the hearing of the appeal on an urgent basis. Those appeals were heard. Mr. Peter Knox, King's Counsel from the English Bar, represented me in the wasted cost order appeal, and I represented Mr. Enriquez in the other two appeals. Today, I'm pleased to announce that mere weeks after the hearing, the Caribbean Court of Justice has issued orders allowing two of the appeals. They have allowed the appeal with respect to the refusal to grant the injunction, and they have allowed the appeal with respect to the wasted cost order imposed against me. The appeal in respect of the bias matter, they have remitted that to the judge for him to decide.
So there we go, people at home and abroad. I want to know how the Prime Minister will say that this is moot because they are already doing the redistricting. When the government attorney had attacked Mr. Ramlogan, and I don't have to say what he said, but people should know what the government attorney had said about Mr. Ramlogan when they issued that cost on him. I believe it was what, $30,000, Mr. Brackett?
Yes, sir. Somewhere around there, 30, 35. I don't recall exactly the number right now off the top of my head.
So how can it be moved?
It was just punitive. It was just malicious and gratuitous at that because they had already said they weren't going to do that.
The way he did that, it is my belief that that falls under defamation of character. Being an attorney and was attacked. So I don't see this being moved because you know what? Mr. Ramlogan has the right to file against the government attorney and the government for that.
They were trying to discredit his ability to function in Belize, as I had stipulated earlier, and on that basis, to marginalize the possibility of Mr. Enriquez having any support or to discourage Mr. Ramlogan. It was all a political gangsterism game that they were trying to pull off, right? So the case would fall apart because they don't want to answer to the substance of the Section 90 violation of the Constitution. They come up with all these side games that they try to play and distract and focus on instead of focus on responding to the constitutional violation and remedy it. The Prime Minister, as you just earlier said, Greg, is stipulating that this case should be moot because he's saying that it is moot. But I'm going to give him the benefit of the doubt that he doesn't understand proper way of communication in terms of public communication, because it appears to me that this gentleman lies unnecessarily, and sometimes it's because that he doesn't know better or know otherwise. So I want to give him a little, way to justify some of his misbehavior. But the bottom line is that when he is saying that this matter is moot, he doesn't understand the legal process and procedures. He doesn't understand what the High Court said. In other words, he would like for what he is saying to trump the High Court final decision in regards to having the case go all the way back and being dealt with how it should have been dealt with in the first place, as compared to how they try to sideline and push the thing out. They threw the case. And the High Court is telling them, you have no such justification to throw a valid constitutional case. Address the constitutionality of the case and stop the use side. You know, that's what they said in their statement that they rendered. technicalities cannot override the constitutional breach. Go back and
Exactly.
answer the case.
Exactly. And you know what? We
We have
have
been saying
seen
that.
it.
We have been saying that, Greg. You and I have been saying that from the very beginning of
Right.
this process.
Right. But we have seen it. Whenever it does not, Mr. Brackett, whenever it does not go their way, they try to get around it. A prime example is the 13th Amendment. They did not want to appeal it because they knew they would lose if it goes to the CCJ. So they try to come up with the 13th Amendment and try to take it back retroactively to prevent these young men from getting any money and not to.
And they still haven't paid those young men yet, you know. They still have not made their payments. They just let the
But
time.
not only that, they lost another one, constitutionality and the 13-year-old. But
Mhm.
put aside that, the Prime Minister said that he had speak on Monday he would have spoken with Mr. Musa. Let's listen to the tape to hear what Mr. Musa said.
The ongoing redivision of electoral boundaries remains one of the most important undertakings at this time. This exercise reviews and updates constituency boundaries to reflect changes in population and settlement patterns across the country. It involves data analysis, mapping and consultation to ensure that electoral divisions are properly structured and administratively sound. This work continues with careful attention as it directly shapes how representation is organized across Belize. In preparation for the 2027 March municipal elections, the department continues to coordinate and deliver the systems required for a smooth and credible process. Each phase of election readiness receives focused attention to ensure that Belizeans participate in an environment that is orderly, transparent, and accessible. Mr. Speaker, this renewed mandate has now been issued by the Prime Minister, and the Election and Boundaries Commission is committed to completing this exercise of the 31 divisions by the end of this year.
I will tell you what this
Go
does,
ahead, go ahead.
Mr. Brackett.
Go ahead.
People at home and abroad, we will remember this case because you see that mood that the Prime Minister said about the ruling from the CCJ. If they fail to carry out one division or two divisions in this country, the whole municipal election will be null and void. Did you heard what I said, Mr. Brackett?
Long time, sir.
Okay, go ahead, sir.
When they're saying that they're doing what they were supposed to have done, at least when they first got into office, because this suit was going on before they got into office. And they came into office saying that they were going to take care of it. They're in office for 2 terms now, and they still haven't taken care of it. No, because the court is demanding that they do something about it. They're trying to offer up the idea that they're going to spend between now and the end of the year to try and get it done. Since the new term start, they could have already got that matter done from then till now. Because it just take a couple, what? We did the calculations, Greg, and one person can do all of those things with one personnel support in less than 8 hours. In other words, less than 1 day's work for 2 people. Okay? A senior statistician and somebody to help them, do the typing or the entering of the information, or a senior clerk into the system. It shouldn't take them until the end of the year We have proven that it takes 3 minutes to do each division. And you have 31 division, which amounts to what? 91, 93, 96 minutes, something like that. 93 minutes. 93 minutes is 1 hour and a half, approximately. You give them a whole day to do the damn job. Let's say they're not proficient enough to be able to do it, then just give them 2 days, twice as much. Give them 3 days, give them 5, give them 10, give them 30 days. It shouldn't take a whole year and more, is my point. They are all on staff getting paid regular payment. You know, they're getting paid 8 hours a day, each person. That department have probably about 50 plus employees. Don't tell me that they haven't spent enough money to get that stuff done, or that it's because of money why they couldn't get it done. It doesn't make sense. We show them on this platform right here, on this same Belizean affairs stuff, the system that they could use, how to use it, and how to get the job done. It would have cost them less money than the amount of money that they are putting out to pay lawyers to defend the indefensible and to continue violating the Constitution. Are they not aware of that? Or do they just want to give their lawyer's friend some money out of the treasury?
But Mr. Brackett, even the senior attorney that used to work for them, Mr. Martelek, said it was easy to be, it can be done easy.
From 2012, he said that?
Yes.
Imagine.
From 2012. So I guess they had no intention to do it.
Which is the point. That is precisely the point. Nobody gonna force them to do what they don't want to do. So they will snub their way through, kill the time, and whatever happen. They don't care. Some of them should go to jail, or some of them should have to pay out of their pocket for their transgressions. Then they will be a bit more forthcoming.
Go ahead and do your closing, sir.
Yeah. I have a little thing that I wanted to use. Let me see what I'm. Okay, there it is. Just a second. I need to put on my glasses just to make sure I know say the wrong thing. I had a. Where is it? That's not what I want. Just a second, please. Bear me a few minutes here. Let me pull up something that I want to. No, that's not what I need. Okay, that's not what I need. Oh man, that's not what I need either. I'm sorry, I'm bumbling a little bit here. I'm trying to retrieve something and I can't find exactly where I have it located. Okay. It appears I may not be able to find what I'm looking for. I thought I would just pull it up quickly and it's not coming up for whatever reason. Okay, I think I might have to forego that. I really wanted was to read it because it's something that I had written in. No, that's not it. Okay, I can't find it. I give up. I'm using too much time. Greg, do you want to just close this out? You have a last comment on what you had presented just now, and then just close this out for tonight?
No, sir. You can just go ahead and do the closing.
Yeah, I was hoping to do the closing with that material that I was looking for, but I couldn't locate it, so I decided to give up. Okay, we could try one more. No opportunity here. Okay. I have another way how I could get to it. Let me try that. There's a much quicker way. Okay. Yeah, right here. I think I might be able to get it right from here. Okay. Just a minute. Let me see quickly. Okay. Yeah, here it is. I found it quick. Shucks. Okay. Yeah, I'll use this as my closeout for tonight's program. It's a commentary that I had made the last time I dealt with it was 3 days ago. So I'll just go ahead and read this. It says the following comments were made by Leonard Brackett to Mr. Jeremy A. Enriquez on Mr. Enriquez and lawyer, senior counsel Mr. Arnan Ramlogan's successful appeal to the Caribbean Court of Justice, CCJ, and I entitled it Enriquez and Ramlogan, ICJ. It shouldn't be ICJ, it should be ICC. So that was a misnomer on my part. Their vindication. And it goes on to read as follows. Mr. Jeremy Enriquez, congratulations and thanks to you and your team, my dear esteemed learned patriot, icon, venerable brother, and vanguard of Belize. On your persistence and dedicated, successful effort at the Caribbean Court of Justice to gain vindication as an advocate for yourself and our Belizean people on our rule of law democracy and the preeminence of Belize Constitution and our country's patrimony, Belize. I went on to say, I predicted and expected such results or outcome during our Belizean Affairs show, as I previously stipulated earlier tonight, that we have done so many times before. Because of the local Belize Supreme Court / High Court and the Appellate Court failure to vindicate and abide and rule by the prescripts of the Belize Constitution. The Belize Constitution is the supreme law of Belize, as cited in Section 2, subsection 1. God's continuous blessing on you and your team and rest of family, always, my dear esteemed learned brother. That was a tribute and a kudos to the gentleman, Mr. Jeremy Enriquez, as well as his lawyer, Mr. Ramlogan, for the fight that they put up against the whole government of Belize and the treasury of Belize. Thank God they were able to persist, because had they not, again, because Mr. Ramlogan is a very experienced international lawyer, by the way, and he was able to carry the day on behalf of Mr. Enriquez. Otherwise, we will not be where we are today. We'll still have these jackals and scarflaws, running roughshod over us. But at least in this instance, or compromised Belize legal system is being taken to task, not only by us, as we have been doing, but by our final court of jurisdiction at the Caribbean Court of Justice. And all I could say for that is, hooray, 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 thank God. I yield back, sir. Could you play us out if you have a song or something?
Thank you, Mr. Chairman. With that said, I would like to say good night to you, the people at home and abroad. Thank those of you who will tune in after our program and those who have tuned in. I want to remind you that on Monday night, we will bring to you another episode of Belizean Affair. With that said, I want to say good night.
We want everybody some of your Ereba. Give me some of that cassava. We want Ereba. We want Ereba. Give me some of your